Oftentimes you do have to spend down a joint account in order to qualify for Medicaid, but it's very dependent on the factual scenario. If I have a husband and wife, those accounts are going to be looked at as a countable resource. So whether it's owned by mom, dad, or mom and dad, it's still a countable resource. And for married applicants, and like I've mentioned in other videos, you can keep about half of the assets up to a ceiling. And then single applicants have to be almost completely impoverished before Medicaid will kick in. But there are scenarios depending on how the account was established. Was it an account that's held by mom and child? And were the funds placed into the account by mom or mom and child? So oftentimes, depending on the account, if I can show that the funds were placed into that account by a non-applicant or a child, for example, then those assets might not need to be spent down. So in our process, we look at each asset, how each asset was created, where the funds came from, who contributed to the assets to that account, and then we categorize them as to what is a countable resource, what is an exempt resource, and what is an excluded resource. The devil is in the details, so they say. Just because you have a joint account doesn't mean you have to spend it down, but oftentimes you will. If you have concerns about the accessibility of account funds to be taken in the event that you have a loved one that needs long-term care, give us a call. We'll help you sort out the details and give you every option that we can in order to protect those funds from having to be spent down in the first place.